Welcome to you all. You are now currently with us at the ICAO Legal Seminar. So we'll now officially start the session where we will share various ideas, and each session will be led by a moderator. And before we start the session, I would like to inform you that there will be Q&A time at the very end of each session. So I'm sure that some questions arose during the session. So if you have any questions, we would like to pass off the microphone to the participants on site. Please raise your hand. And also, if any of our YouTube viewers have any questions, please post them on the comment section of the YouTube channel. They will be shown to the moderator. So then shall we open the doors to the first session of 2022 ICAO Legal Seminar. First seminar on ICAO's work in the legal field will be moderated by the Director Kyung-soo Yu from Ministry of Land, Infrastructure and Transport of Republic of Korea. I would like to hand off the microphone to the moderator. Ladies and gentlemen, please welcome the moderator with a big round of applause.
네, 여러분 안녕하십니까?
Good morning.
Good morning, good afternoon, and good evening to all participants in this session, depending on where you are. It's my great pleasure to be moderator of the session, and I would like to once again extend a warm welcome to all here, and also the others watching on online streaming. Thank you very much. This session will be entitled "In the ICAO Work in the Legal Field." Before I get started, on behalf of the session, I would like to congratulate again two important occasions: the 70th year anniversary of Korea's membership in ICAO, and second, the 75th anniversary of creation ICAO Legal Committee since 1947. So what are you going to do for this seminar? Next 1.5 hours, we'd like to invite ICAO legal officer from Montreal who served 193 contracting states in terms of legal affairs. It's valuable time for us. So they'll make presentations for us about the recent developments in the legal field of international aviation. After their presentation, we're going to give you an opportunity to ask questions or make comments. So be ready. If you have questions during the session, as you already guided, those who are online, you can submit your questions with your name and organization. Okay, without further ado, I'm going to start by saying a few words about the aviation feature. The aviation connects the world and is a driving force of economy. The aviation led us much smaller world since its success power-driven flight about 1 century ago. Without doubt, global aviation system we see today could not be possible without ICAO leadership and international legal framework. As a global regulator, ICAO has been tremendous success over the last 75 years. The various documents from ICAO played a vital role in making sure and enhancing global aviation systems safe, secure, efficient, and sustainable. Nevertheless, looking into recent years in aviation, what's happening? Changes are more rapid than past. Challenges features unprecedented per se. In particular, the rapid technology innovation and the havoc of the pandemic and security issues requires agile response with priority, nationally, regionally, globally. Against this backdrop, I cannot stress enough the importance of collaboration and cooperation within global community in making internationally acceptable regulations for current and future aviation system. That's why we call for better understanding of work on the international legal instruments and regulatory documents from the ICAO. So now, I'm very delighted to introduce our distinguished panelists from Montreal. From my side, Mr. Michael Gill, the Director of the Legal Bureau of ICAO. He was appointed as Director, Legal Bureau in September 2021. From 2013 until his appointment to ICAO, he served in dual roles of Director, Aviation Environments, IATA, and Executive Director of ATAG in Geneva. Prior to that, he had also worked as an aviation lawyer in private practice in London and Paris. Next to him, Mr. Andrew Opplert. Andrew joined the Legal Bureau in 2011 as the first legal professional from Africa. He's working as a legal officer, handling various portfolios on the general program of ICAO in the legal field. Prior to joining ICAO, he worked for 10 years as Chief Legal Advisor to the National Civil Aviation Administration of Botswana and Uganda. He's an instructor of the International Air Law course on the ICAO Train Air Flows program. At the end, last but not least, Mr. Matthew Bourgois joined ICAO Legal Bureau in 2016 and currently holds the position of Associate Legal Officer. For the past 7 years, he also acted as a sessional lecturer in air and space law in Polytechnic Montreal. Matthew is a registered attorney in Canada. So, ladies and gentlemen, join me welcoming our speaker with a big round of applause. So the first speaker is Director of the MIC. He will take us through the ICAO Legal Committee and 75 years of codification and development of international air law. So Mike, the floor is yours.
Thank you, dear moderator, for your kind words of introduction. Minister No, Secretary General, Excellencies, distinguished ICAO Council members, ladies and gentlemen, Pan Gap Sim Nida, as I've been told to pronounce in my best Korean. Forgive me if my pronunciation was inaccurate, but it really is an absolute pleasure to be with you here in Seoul for this very important and we hope a very interesting seminar. What I think is a real pleasure from the perspective of the ICAO Secretariat and the ICAO Legal Bureau is both to see the large number of attendees that we have online. It really shows the breadth of our participants, the importance of the topics, the real spread of our international aviation legal community. But it's also great to see such a large number of participants here physically in the room. What a pleasure, what a privilege to be able to meet again physically, something I don't think any of us will take for granted again as we emerge from the pandemic. It's my pleasure today to try and set the scene for some of the more substantive discussions that we'll have over the next couple of days. And I wanted to do that by giving an overview of ICAO itself, established by the convention, as well as then looking into the work of the ICAO Legal Committee and some of the more substantive topics that the organization has done in the legal field in recent years. But the idea behind my introductory presentation really is to set the scene for some of the more substantive topics. I should say that there are some detailed slides accompanying my presentation. They're really meant as reference material for you to be able to take away and use after the event. I won't go through all of the slides in detail, but hopefully they will, as I say, provide a useful reference for you for afterwards. Now, just reminding ourselves how ICAO came into existence, and it's through our, if you like, constitutional document, the Chicago Convention. It was adopted in December of 1944, came into effect in 1947, as we've heard. Amazingly, that all happened before the Second World War was even over. It happened before the United Nations Charter was even adopted. ICAO was really something of a precursor in bringing together the international community in the post-World War II environment. We now number some 193 member states. The most recent joined in 2019, that was Dominica. But the wording of the convention, I think, in its preambular text, is really as important and as relevant today as it was some 75 years ago. The objectives to foster the planning and development of international air transport to ensure the safe and orderly development of civil aviation. And it's an instrument which has really, I think, stood the test of time, only having seen 2 substantive amendments to the convention in its existence, and I'll mention them in a bit more detail shortly. Now, looking to our mission statement, I think you'll see this up on the screen there. ICAO's objective to serve as a global forum for states for international civil aviation. And those few words, I think, say a great deal. International relations really is at the heart of what ICAO does, what ICAO is there to do for its member states, to provide a forum through which states can exchange views and ideas. But we have a very somewhat limited mandate around civil aviation and international civil aviation. So it's, I think, important by way of reminder that our mission statement really makes that quite clear. Within that mission statement, however, ICAO has adopted a number of strategic objectives, and those are done for each triennium, and currently our strategic objectives relate to safety, to improving efficiency, security and facilitation, sound and economical civil aviation, and minimizing adverse environmental effects. Now, what's interesting from a lawyer is that none of these strategic objectives specifically mention legal work, but I think that it's clear they're all areas where legal expertise, whether it's from the Secretariat side or whether it's from the member states or contributions from industry, are absolutely fundamental. So the importance of what we're going to discuss in the next couple of days in underpinning the strategic objectives, I think, is key. I'm sure many of you are aware of the main bodies of ICAO, which were established by the Chicago Convention. The Assembly, our sovereign body made up of all member states, which meets at least once every 3 years, and will convene again in September of this year. Interestingly, for the first time ever in a hybrid format. There are obviously a number of practical challenges around that, but challenges we think that the organization will be more than able to meet. The convention then also established the Council, our permanent governing body made up of 36 member states. And what's interesting is that the convention attributed to the Council a number of mandatory functions, establishing the Air Navigation Commission, appointing our Secretary General, adopting technical legislation in the form of the annexes, and the kind of catch-all in Article 54, considering any matter relating to the convention which a member state refers to it. But the convention also attributed a number of permissive functions for the Council also. And then, as I mentioned, the convention established the Air Navigation Commission. That's made up of some 19 technical experts with suitable experience in the science and the practice of aeronautics. And the main task of the commission, of course, is to consider and recommend the amendment or the adoption of technical annexes to the convention. And I'll mention those in a bit more detail in a moment. Recently, in 2016, the Assembly recommended an increase in the size of both the Council and the Air Navigation Commission. Those amendments have not yet entered into force, but in due course we hope and we anticipate that they will, increasing the size of those two bodies. A very brief word on the Secretariat, which in essence is the executive arm of the organisation, with our 5 bureaus, of which legal and external relations is one, as well as our very important regional offices, making up our staff of some 700 employees. Now, a few more comments on the ICAO Legal Committee. As has been noted, we're celebrating its 75th anniversary this year. It's quite a significant milestone if you think about everything that's happened in the world over the last 75 years, and the ICAO Legal Committee has worked throughout that on a number of areas affecting international air law. It actually, it was established by the first ICAO Assembly, the committee, but it was actually led on from a previous committee of experts, the CITEJA, which had been established for a number of years and which had already worked on some significant international air law treaties. The main functions of the legal committee are to advise the Council on matters of air law, to make recommendations on studies in public and private air law, and importantly, to prepare and negotiate drafts of international air law conventions. And we just recently completed our 38th session of the ICAO Legal Committee just last month. The 3 main functions in the Legal Committee's constitution are, as I mentioned, drafting the texts of treaties, undertaking studies on particular points of air law, for example, the legal status of an aircraft, or the aircraft commander, legal aspects of RPAS or drones, and then separately the development of guidance material which supports the implementation of some of those international treaties. So, for example, and we'll hear a topic we'll hear about later in the seminar, guidance material around the handling of unruly or disruptive passengers. But the committee has been responsible for the development of some 24 international treaties in the course of its 75 years of existence. That's one international treaty roughly every 3 years, which is no small undertaking, as I'm sure you can imagine. Now, I wanted to say a few words about the treaty-making process within ICAO, and there's really 2 paths whereby international agreements can come together under ICAO. We're either talking about amendments to the convention itself or these international air law instruments which I mentioned. If we're referring to amendments to the convention itself, and as was noted by Ambassador Kim earlier this morning, that relates to Article 94 of the convention, where the Assembly itself is able to amend the convention with a 2/3 vote. And it's by that process that, for example, the increase in the size of the Council and the Air Navigation Commission, which I mentioned, were adopted. There is, however, something of a difficulty for those amendments to the convention to then come into force. So they're adopted by the Assembly, but for them to then come into force, it requires 2/3 of the total number of contracting states to ratify that amendment. And that's why some of the changes, some of those amendments to the convention take some time to come through. So that's for amendments to the convention itself. If we're looking at those multilateral air law treaties, which I noted, of which there have been some 24, the process is somewhat different. First of all, the topic at hand needs to be included into the work program of the legal committee itself. And that's why the presentations you're going to hear shortly are really so important, because as a preliminary step, we like to build consensus amongst the member states that a particular topic is deserving of further work within the legal committee process. And items can be put forward to the legal committee for consideration on its work programme by the committee members themselves, by the Assembly, or indeed by the Council. And that has, all of those different scenarios have happened over time. Once there is agreement that an item should be included on the committee's work programme, the Legal Bureau, acting as the Secretariat, then undertakes a study of the problem, either with a working group or study group made up of states, often with invitations to industry representatives also. And depending on how those discussions, that study goes ahead, as in time a text matures, a final draft would be considered by the ICAO Council before then being proposed to a diplomatic conference to refine and hopefully adopt the text of the instrument. So that was the process that was most recently followed for the most recent ICAO treaty, the Montreal Protocol of 2014, which amended the Tokyo Convention of 1963 that relates to the issue of unruly and disruptive passengers. As I mentioned, there'll be specific discussions on that later. And here you have a summary of the different areas where we have seen that multilateral treaty negotiation process being followed. The 24 treaties which I mentioned that have been adopted over the lifetime of the legal committee. And it covers a broad range of topics, from air carrier liability for passengers and for cargo, air carrier liability for those who may be injured or suffer death on the ground, third-party surface victims. It also relates to the broad range of aviation safety and security treaties, as well as the adoption of treaties in the field of aircraft financing. And I think it's fair to say that the ICAO lawmaking framework has had significant success, particularly some of the older treaties referred to here, where you have virtually universal acceptance to a degree which is rare even amongst other UN bodies. And I think rightfully the legal committee should be proud of the track record it's had in the adoption of the treaties in this fairly broad range of different topics. Now, you're going to hear shortly in a bit more detail what the current work program of the legal committee is, but again, I wanted to underline the importance of that, of the work program itself, because that's really the starting point for any future lawmaking process which may be undertaken by the ICAO legal committee. And so this year, as I noted, we're celebrating the 75th anniversary. The committee itself was established by the first ICAO Assembly in 1947. Since then, it's held some 38 sessions under the leadership of some very distinguished legal scholars in the aviation field as acting as its chairpersons. But the committee continues to take a leadership role within ICAO, within the broader aviation law community, looking at new emerging issues affecting air law. And I firmly believe the committee has a fundamental role to play in doing that. And that's why the Legal Bureau is so proud to be able to support the work of the Legal Committee in doing that. But I think it is also important to note those achievements which I mentioned, the significant contribution that has been made to international air law over those 75 years. And that's why at our most recent session, as I mentioned just last month, the Legal Committee agreed to recommend to the upcoming Assembly that a resolution should be adopted recognizing that contribution of the Legal Committee to the development and codification of international law. And we hope that the Assembly will agree to adopt that resolution at the forthcoming session. So that's what you might term black letter international air law, the adoption of international treaties in these many and varied areas which I mentioned. But there is also a significant area of lawmaking, if I can call it that, in ICAO, which isn't always classified as such, but it is arguably ICAO's most significant and important work, and that's the adoption of the technical legislation under ICAO through the adoption of standards and recommended practices. Articles 37 and 38 of the Convention give the authority to ICAO to adopt standards and recommended practices, or SARPs, and really they're intended to deal with matters where there is the need for uniformity to facilitate and improve air navigation in a whole range of technical matters: communication systems, air navigation aids, airports, the rules of the air traffic control practices, airworthiness of aircraft, and so on and so on. The SARPs really cover such a broad range of topics, but they are, as I mentioned, a fundamental body of legislative work that ICAO engages in. Broadly speaking, a standard is a specification where it's recognized it is necessary for the safety or the efficiency of international air navigation. A recommended practice is a specification where it is seen as being desirable for it to be adopted in the interests of safety or efficiency. And here on this slide, you see the, as of today, 19 annexes which have been adopted, some 12,000 standards and recommended practices. That is, as I said, a significant body of legislative work. The adoption of SARPs, I'm sure many of you are aware, has its own process. It's an interesting process, I think, because it shows the power of consultation which takes place between states and between states and ICAO. It shows the value of consultation, the value of commentary on proposals for SARPs, which are then finally adopted through the Council. But it goes back to one of the initial points made: the role of lawyers, the need for legal expertise is key really at all stages of the process of adoption of the SARPs. So whilst myself and colleagues in the Legal Bureau, we don't have the primary responsibility within the Secretariat to develop and adopt the SARPs, that rests largely with our colleagues in the Air Navigation Bureau or the Air Transport Bureau. But we do provide legal advice and assistance both on the substance as well as the process throughout the whole SARPs adoption framework. And again, I think it really underlines to me how important we as lawyers can be in facilitating the adoption of our internal ICAO legislation. We can facilitate the consultation process, and we can facilitate the discussions on substance and on process. And again, the role of lawyers in that, I believe, is really significant. Before I conclude, I'm going to take this opportunity for a small plug, if I can, for a particular initiative within ICAO in our global aviation training program. We offer a specific course on international air law. It provides the whole range of topics which we believe representatives, lawyers in civil aviation administrations, airports, ANSPs, and even the broader industry will need in order to advise, in order to ensure compliance with international air law. And it covers really the whole broad range of topics which I've covered off alluded to in my presentation, and which will be examined in quite some more detail in the coming presentations. And if you refer to the slides in your presentation packs, you'll see the dates and venues for the next round of those training sessions. So let me conclude, ladies and gentlemen, again by underlining what a pleasure it's been to be able to kick off this seminar with some thoughts from my side on the important work of ICAO in the legal field. both lawmaking from a treaty perspective as well as the support to the SARPS process within ICAO, but also really a pledge that I believe the organization should remain at the forefront of new developments in international air law. There are a number of key topics which we're going to look at in the next 2 days where I believe lawyers will have a significant role to play, and we're very much prepared to support the member states in undertaking that work. Thank you very much for your attention.
Thank you, Mike. Very informative presentation. It brought us very broad range of knowledge and experience regarding the ICAO mandate for legally binding document productions, also including ICAO working system for lawmaking and standard making is very important for those who are engaged in the national institutionalizing process. There are many people are from the legal area, the many legal experts and the legal professors and in the audience and regulatory officer and technical experts from the industry. They all are relevant to these ICAO documents. Whatever the type and form of documents from ICAO is regarded in the regulator state kind of regulatory information and material. So it's very important when each state governments transforming into national regulatory documents. So as I already mentioned, it's very important to understand better the working process and system, the implication of ICAO legal document. Thank you for that. So next speaker is Mr. Andrew Offlet. He'll make a presentation about the outcomes for the 38th session of the Legal Committee and preparing for the 41st ICAO Assembly. Andrew, you have the floor.
Thank you, Mr. Chung Soo Yu, and hello to everyone present here in person and those joining virtually from wherever you are around the world. This is my second time here in Seoul, Korea. I spoke at a similar event a few years back in 2015, and I'm grateful for the privilege and opportunity to be here again. Hamsamida. Most of my presentation will cover the outcomes of the 38th session of the Legal Committee that was held recently, and at the end, I will also provide some brief information about the preparations for the 41st ICAO Assembly that takes place September, October this year. Regarding the work program of the Legal Committee, my focus would be to provide background information as to how the items were included, what's the genesis, and the general nature of the issues, the tasks involved, and the current status. It will not necessarily be an in-depth dive into the issues. So that list has already been introduced by Michael, and it's a list of items on the work program of the Legal Committee, as you've heard. It will be reviewed further by the Council and the Assembly because, according to its constitution, the Legal Committee shall determine, subject to the approval of the Council, its general work program. And the ICAO Assembly can also refer topics to the committee for study. So the 38th session of the Legal Committee was held only recently on 22nd to 25th March, and it was the first time that a meeting of this body was held in a virtual format. So at the end of this session, the committee adopted that work program that is displayed on this slide. In fact, the items are not new. the committee undertook some reordering of the items depending on the status of the work. So the Council will look at this work program during its upcoming 226th session in June, and also the Assembly will look at the program in September, October. There could be some changes or not. Moving on to the first item on the work program, it relates to the review of the ICAO rules for the settlement of differences. So there is a working group established to conduct this work. This group was established in 2019 in order to assist the legal committee to revise the ICAO rules for the settlement of differences. And these rules have not been revised substantially since they were adopted by the Council in 1957. At the time, the rules were based mainly on the rules of the International Court of Justice that were introduced in 1946. So I guess they are overdue for modernization. The rules for settlement of disputes apply to disputes that are brought to the Council by member states under the Chicago Convention and other treaties adopted in 1944. So in reviewing these rules, the working group that I mentioned is taking into account comparable documents in use elsewhere in the UN system, in particular the International Court of Justice, and to try and develop new and innovative mechanisms to facilitate the settlement of differences in a timely, expeditious, and transparent fashion. So this working group has experts from 22 member states, and it is chaired by Mr. Terry Olson from France. The vice chairperson is Mr. John Thatchett from Canada, and the group's rapporteur is Mr. David Lau from Singapore. So the recent legal committee looked at progress on this item and acknowledged that further meetings of the working group are needed, and as a consequence, the working group will continue and complete its work and present the draft rules for consideration by the next session of the legal committee. That will be the 39th session, possibly in 2023. This is just on this slide a few examples of some of the issues that are being looked at by the working group. As an example, they will look at issues such as whether practice directions, provisional measures, as well as provisions allowing for virtual meetings should be included in the revised set of rules. There will be an opportunity for further in-depth discussion about settlement of disputes at ICAO when this is presented to you by other speakers at this event tomorrow. The next item on the work program relates to international legal aspects of unmanned pilotless aircraft operations and their integration into civil aviation. The Legal Affairs and External Relations Bureau undertook a study of the issue of liability from ARPAS operations when the issue was first introduced in 2013. That study was completed and reported back to the committee, and it was concluded that while the study of legal issues should remain on the work program, since an international, there needs to be an international legal framework relative to other aspects of ARPAS operations, which are international in nature, such as operations on the high seas, cross-border operations, and changes in the possession and control of the remotely piloted aircraft. I must mention that this study had concluded that the current regime is legally adequate to accommodate ARPAS technology. So that issue is is closed. The group will only go and look at these other international aspects that I mentioned. So although initially this was to be undertaken by a working group of the legal committee, it was decided due to resource management considerations that the Secretariat could undertake through a study group legal issues related to pilotless aircraft, and that such a study group was established in February 2020, just before the pandemic broke. Again, this item will be covered in in-depth discussions in other presentations tomorrow. The next item on the program is entitled Processes and Procedures for States to Fulfill Their Obligations under Article 12 of the Chicago Convention. What's the background? On 29 September 2006, a Boeing 737 aircraft operated by Brazilian carrier Gol collided in mid-air with a US-registered Embraer 600 legacy business jet, leaving 154 crew and passengers dead. This was after the 737 crashed into a jungle following the collision. The business jet, on the other hand, landed with no fatalities. 10 years later, in 2016, the Brazilian authorities filed a dispute with ICAO, stipulating that the US authorities had failed to deal appropriately with the alleged violations of Brazilian air regulations on the part of the American pilots of the Embraer business jet, and thereby contravened the provisions of Article 12 of the Chicago Convention. Several ICAO bodies have considered the issue of safety enforcement, and we had a high-level safety conference in 2015. There was a legal committee in 2015, the 40th Assembly in 2019, and Brazil and the US presented working papers to these bodies, and following that, this item was added to the work program of the legal committee. But I must emphasize that this is just one example of the issues at hand, because under Article 12 of the Chicago Convention, as you'll see, the state of registry has the responsibility for ensuring that the aircraft complies with the rules and regulations relating to the flight and maneuver of aircraft in force, wherever such an aircraft may be, as well as for the prosecution of persons violating those rules and regulations. So, in order to assist states in the implementation of Article 12, the Article 12 Task Force of the Secretariat was established in April 2021. And the next slide describes the scope of work, the tasks and deliverables of this task force, which is currently comprised of experts from a number of states. So at the end of that process, it is expected that the task force will develop a process for efficient communication of alleged infractions or violations of regulations between the concerned states, and recommend procedures and best practices regarding investigations of violations and enforcement. So the meetings began in November, virtually, in November of 2021. The chairperson of this task force is Ms. Susanna Metsalampi from Finland, and the vice chair is Dr. Jonathan Alec from Australia. Additional meetings of the task force will continue this year, and the outcomes will also be reported to the 39th session of the legal committee. So these are some of the implementation challenges that have been identified so far. During the first meeting, experts from the states presented challenges that are faced by their states with respect to the implementation of Article 12. We see the lack of efficient and timely communication is identified. There is also difficulty for states to have full confidence in evidence gathered in another state in order to proceed with an enforcement action. There is also the issue of timely receipt of notifications of violations. In some cases, the notification is received after the foreign operator has already left the state which should be enforcing the regulation. Another issue relates to occurrences over the high seas and in delegated airspace. Next item relates to acts or offenses of concern to the international aviation community that are not adequately covered by existing air law instruments. A key task that was undertaken under this work program item was the publication in June 2019 of the manual on the legal aspects of unruly and disruptive passengers, ICAO Doc 10117, and this followed the work over a couple of years by a task force on this issue. And this manual updates prior guidance that existed in the form of a circular, which required updating as a result of the adoption of the Montreal Protocol in 2014. I must say that there was concern at the time that the frequency and severity of incidents involving unruly and disruptive behavior was escalating, and hence that's why the work was previously undertaken leading to the adoption of the Montreal Protocol 2014 and the manual as guidance. More recently, with the pandemic, the Secretariat has continued to monitor events. You must have seen a lot of press coverage about implementation of public health and safety measures on board aircraft, particularly the wearing of masks, where there has been resistance and interactions between crew and passengers. So as the Civil Aviation Recovery Task Force was undertaking work on this subject, there was input requested about whether the existing framework was sufficient to deal with this, the apparent escalation in these incidents. The CAT report, I think it was the CAT 1 version, highlighted actions that states could take. In general, it was concluded that the legal framework was sufficient, but that states could review their national legislation to ensure that unruly and disruptive behavior relative to COVID-19 measures was properly covered. Again, you're going to be hearing more about this topic from other speakers. Under the same item, there is related work that is focused on the issue of cyber threats against civil aviation. The work undertaken with regard to cyber threats is mainly to study the applicability of air law instruments to cyber attacks and form the view as to whether they are adequate to deal with cyber attacks as crimes. This review was undertaken at ICAO by the research subgroup on legal aspects, which falls under the Secretariat Study Group on cybersecurity. And the study was reported to the recently concluded session of the Legal Committee. It generally concludes that the existing international legal framework is partially adequate to address cyber threats. Some gaps were identified and will form the part of continuing work. For example, there was the issue of terminologies with an attack by cyber means could be interpreted to amount to a use of a weapon or a device or use of force. So the older air law instruments that we shall be seeing later on were less specific than the newer ones in covering situations that relate to cyber attacks as well. Meanwhile, there is a new governance structure for cybersecurity at ICAO with the recent establishment of the cybersecurity panel that will be reporting to the Aviation Security Committee. Again, this item I will cover in more detail in the presentation that I will make tomorrow. You have heard about the ratification of international air law instruments, and that as 24 instruments have been adopted under the auspices of ICAO. The adoption is not an end in itself. They must become effective following their ratification by states. So the organization undertakes various activities to promote the consideration by states of the ratification of these instruments. And in that picture, representative of Saudi Arabia on the Council of ICAO is handing over instruments of ratification to the Secretary General. GNSS, legal issues relating to global navigation services is a topic that has not gained a lot of traction so far, but I guess we will be hearing more about it in the future as arrangements are being made to ramp up activity in that area. The next item, the seventh one, is consideration of guidance on conflicts of interest in civil aviation. The item has been on the work program of the legal committee since 2010. And at that time, there was a proposal by the United States made to the Assembly at the 37th session, and the proposal emphasized the need to establish and preserve a clear separation between civil aviation authorities and the activities that they oversee, considering that the rule of law, especially the objective, disinterested exercise of regulatory responsibilities, is critical to effective safety oversight. What does it mean? Of course, it begins with understanding what we mean by what is a conflict of interest. And I could illustrate that instead of reading out everything that is on the screen with a hypothetical situation. Imagine you are a Director General of Civil Aviation who holds a pilot's license. And that pilot's license is to be renewed by your licensing department that reports to you. So how do you navigate that situation while assuring the general public that whatever action your subordinates are taking is being done fairly and transparently? On the other hand, imagine you are a legal officer who is reporting to that Director General, and the licensing department has decided to withhold that pilot's license on medical grounds, and your DG is asking you for advice. Again, how do you navigate that situation? So, the information, the definition is on the slide. It's about having an interest that may be perceived to improperly influence or interfere with the performance of your duties as an individual. But it also exists at the level of the organization. The organization has relationships with other organizations. Maybe it's a regulator which has to engage with service providers, and that relationship gives rise to a conflict of interest situation. The issue is how to deal with or mitigate that situation. So the next two slides talk about, list the kinds of relationships that are at play here, and also some of the measures that could be taken to mitigate, because the overall objective of the work under this item was to consider whether there was a need to develop rules to assist member states on measures to be used to detect, avoid, mitigate, and manage conflicts of interest to ensure transparency and accountability in their frameworks. However, it is acknowledged that given the particular circumstances of certain states, shortage of aviation personnel, the situation is unavoidable, so the solution is not to prohibit entirely some of these relationships, but to balance the risks and look at ways of mitigating or managing them. So the ICAO work on this resulted on a compilation of various ICAO provisions on conflicts of interest that covers material that is contained in ICAO annexes and over a dozen ICAO manuals. An example is Doc 10047 on aviation security oversight. The manual highlights how to avoid potential conflict of interest in a situation where the state regulator is a service provider, for example. And again, this is just a sample provision in the Civil Aviation Act dealing with managing this situation where the minister, for example, is asked not to appoint persons with substantial conflicts of interest in the Civil Aviation Authority. The next item is implementation, and this is the last item on the work program, implementation of Article 12 of the Chicago Convention. Another task force undertook this work and completed it. One of the main outcomes of the work of this task force was a proposal to develop a model certificate of deregistration of aircraft to be included in Annex 7. So that sounds obvious, but the fact of the matter is that while states are required to issue a certificate of registration of aircraft, there was no corresponding requirement to issue a certificate of deregistration. So the work under this item is leading to filling that gap. It is expected that the certificate of deregistration will facilitate the transfer of aircraft from one state to another and harmonize the current practice as a result. Finally, the 41st session of the Assembly, very briefly, progress will be reported to the Legal Commission of the Assembly. As you know, the Assembly will be meeting in a hybrid format, 27 September to 14 October, and we'll review this work program that I've just presented to you, as well as the consolidated statement of continuing ICAO policies in the legal field. So in conclusion, the work program is a living document and will continuously be reviewed to address new and emerging issues in civil aviation. I thank you.
Thank you, Andrew, for keeping your time limit. We are a bit behind our schedule, so we need to hurry up. So Andrew introduced various interesting subjects in the international aviation legal field, and the issue and challenge need to be addressed with a priority in the legal committee. That will bring us later into the stage after the legal committee compose some certain type of the documents. As a customer, the states and other industry, you're waiting for the deliverable from the legal committee. So thank you for your tremendous work done. And our next speaker, last but not least, Mr. Matthew Bourgeois. He'll bring us up to date on overview and status of the ratification of key air law treaties. So, Matthew, you have the floor.
So good morning to all. I wish to say that it is for me an honor to be here today, and I wish to thank as well the Ministry of Land, Infrastructure and Transport for the kind invitation. So my presentation today will aim at providing an overview of the status of ratification of key international air law treaties, as well as to explain the procedure related to the deposit of instrument of ratification with ICAO. So, as you may be aware, ICAO acts as the depository of around 40 international air law instruments, and this number also includes several protocols amending the Chicago Convention. So the key instruments that to be ratified, which will be featured in this presentation today, are the Montreal Convention of 1999, the Beijing Convention, as well as the Beijing Protocol of 2010, the Montreal Protocol of 2014, as well as the protocols amending Articles 50A and 56 of the Chicago Convention. As mentioned by my colleague, Mr. Opolot, in the previous presentation, the ratification or the promotion of ratification of international air law treaties is an item that is on the work program of the legal committee. And in this regard, I just wish to stress that the organization is continuously promoting the ratification of international air law treaties, and I believe that this seminar is a very good example of some of the actions that are taken by the organization to promote the ratification of international air law treaties. So moving to the first treaty that I wish to talk about, it's the Montreal Convention of 1999. I'm sure that most of you are probably familiar already with that convention, which provides for rules relating to the liability of international air carrier for passengers, baggage, and cargo. The ICAO Assembly has recognized the importance of ratification and universal acceptance of this convention, and in this regard, the 39th session of the Assembly back in 2016 has adopted a resolution for the promotion of the ratification of the Montreal Convention. As of 1st April 2022, the convention has been ratified by 137 member states. Also, speaking about the Montreal Convention, I wish to highlight that the limits of liability that are contained in the convention have been increased about 3 years ago in 2019, following the periodic review that is provided in the Montreal Convention. So, as you all know, the Montreal Convention of 1999 modernizes the different international treaty regimes that covers airline liability which have been developed since the adoption of the Warsaw Convention of 1929. So until there is a universal acceptance of the Montreal Convention, there will be a patchwork of liability regimes which will continue to exist around the world. The result of that may lead to confusion and complexity in determining which regime covers a particular passenger or a cargo itinerary. So the next treaties that I wish to highlight are the Beijing Instruments of 2010. So the Assembly has also recognized the importance of the universal adoption of this treaty by adopting Resolution A3910 on the promotion of the Beijing Convention and the Beijing Protocol. So these treaties aims at modernizing the legal framework for aviation security, and they criminalize a number of acts constituting new and emerging threats against civil aviation, including certain preparatory acts for the offenses. And I just wish to point out that the Beijing Protocol amends and supplements the Hague Convention of 1970, while the Beijing Convention supplements the Montreal Convention of 1971, as well as the Airport Protocol of 1988. As of 1st April 2022, these two instruments have been ratified by 43 states. Now moving to the Montreal Protocol 2014, I just wish to mention that this protocol amends the Tokyo Convention of 1963 and addresses the issue of unruly and disruptive unruly and disruptive behavior on board aircraft. The protocol also improves the ability of states to expand jurisdiction over the relevant offenses and acts to the state of landing and the state of the operator. The protocol also serves to enhance the global aviation security provisions by expressly extending legal recognition and protections to in-flight security officers. The 40th session of the Assembly, which was held in 2019, has adopted a resolution within the consolidated statement on ICAO policies in the legal field, which urge all states that have not done so to ratify this protocol. As you can see from the maps, there are so far 36 states which have ratified this protocol, which entered into force on 1st January 2020. Now, I just want to move to the 2016 protocols amending Articles 50A and 56 of the Chicago Convention. As mentioned by Mr. Gill in his presentation, these protocols have been adopted by the 39th session of the Assembly back in 2016. The protocol amending Article 50A of the Chicago Convention this protocol aims at expanding the number of seats on the Council from 36 to 40, while the protocol amending Article 56 of the Convention aim at as the objective of increasing the number of seats on the Air Navigation Commission from 19 to 21. As of 1st April 2022, these two protocols have been ratified by 70 states. In order for this protocol to enter into force, 128 ratifications are needed. So we're approximately a bit past halfway, let's say, in the number of ratifications that have been received so far. And there are also some assembly resolutions which are promoting the ratifications of these protocols. I just wish here to highlight that there are currently 7 states from the Asia-Pacific region which are represented on the Council. And whenever the protocol on amending Article 50A of the Chicago Convention may enter into force, this means presumably that there could be an additional seat, an additional state from the Asia-Pacific region which would be elected to the Council of ICAO. However, it is difficult at this time to say how geographically and on which criteria those 4 seats will be allocated. And I just wish to point out that being elected on the Council gives a number of benefits, such as being directly involved in ICAO's work. So, as I mentioned, these protocols have been ratified so far by 70 states, and it is difficult to predict when they will be entering into force. Last time there were an amendment made to Article 50A was in 1990, and it took 13 years for the protocol to enter into force until an extraordinary assembly was convened in 2003, which elected those additional seats on the council. So it may take still maybe presumably between 3 to 5 years before the protocols enter into force. It depends, as you may understand, on the speed of the ratification of these instruments. So moving now to the process for depositing instrument of ratification with the organization, you may all be aware that the process for ratification of a treaty usually involves 2 phases. The first phases is the internal procedure in which a treaty will be passed by a state will be presented in front of its parliament and will be enacted in the law of the state. And then the second phase is called the international procedure, under which a state will notify the depository of a treaty that it has passed legislation and that it will consent to be bound to the provision of the treaties. So, as I mentioned, ICAO acts as depository for 40 international air law treaties, but however, some international air law treaties, for example, the Cape Town Convention or the Aircraft Protocol, are not, ICAO does not act as depository for these two treaties. So just briefly, because time is lacking, I just wish to highlight that whenever a state wishes to deposit an instrument of ratification with the organization, it must ensure that the instrument comply with some of the requirements, such as the title and the date and place of conclusion of the treaty concerned must be expressly specified on the instrument of ratification. It should have also the full name and title of the person signing the instrument, which is Minister of Foreign Affairs, Head of State, Head of Government, or any other person provided with full powers signed by one of these authorities. It should contain also an unambiguous expression of the intent of the government on behalf of the state to consider itself bound by the treaty and to undertake faithfully its provision. It should also contain the date and place where the instrument was issued, as well as contain the original signature. So these are just a few slides to show that there are sometimes some common mistakes which can be found in the instrument, and if the instrument that is presented to ICAO is not complying in form, it may delay the official date of deposit of the instrument, and as we may need to seek further clarification from the state. So it's quite important to ensure whenever an instrument is deposited that it complies, at least in form, with the requirement that I just mentioned. Also, briefly, I just wish to highlight that the website of ICAO contains some useful resources that are at states' disposal in order to assist them with the ratification of international air law treaties. So among these resources, there are administrative package which provides some guidelines for the ratification or the accession to international air law treaties, as well as which contain in their appendix model instrument of ratification, which can be used by states whenever they wish to deposit an instrument of ratification. The ICAO Treaty Collection website also contains a list of parties to all international air law instruments, as well as forms indicating the current status of individual member state with respect to international air law instruments. As another mean to promote the ratification of international air law treaties, just wish to mention that the Legal Affairs and External Relations Bureau of ICAO is planning to host an ICAO treaty event during the 40th session of the Assembly. So basically, this event will take place depending of the evolution of the sanitary measures that are in place in Canada, and it aims at providing special facilities for representatives of member states in the margin of the assembly session for depositing an instrument of ratification to a treaty for which ICAO act as depository. Back 3 years ago, during the 40th session of the Assembly, the inaugural treaty event took place, and it was quite successful. There were 17 depository actions that have been recorded, and several states took the opportunity to meet with officials from the Legal Affairs and External Relations Bureau in order to discuss their status, the status of their state with respect to international air law instruments. And also, I just wish to mention that for any questions or any query with respect to ratification process, states are always invited to contact the Legal Affairs and External Relations Bureau for any questions they may have. So the email addresses are shown on the screen. So this completes my presentation, and I wish to thank you for your attention.
Thank you, Matthew, for your excellent presentation. So, Matthew presented us the various legal instruments yet to be ratified by the states to deal with important security issues and ICAO government's change, which is very interesting. In particular, Article 50A and Article 56, increased seat of the Council and Air Navigation Commission of ICAO, which is a constitutional body kind of the Chicago Convention. So before opening up the questions, be advised that traditionally the session 1 is prepared to provide the state regulator or legal expert and technical expert regarding the progressive work on the international legal field. So this is not for debate or discussion. So I ask you to ask questions you care most about on those issues presented this morning. We got a jam-packed information in a short time. However, we try to take your questions from the audience first. So put up your hands if you have any question on the presentation and any other relevant issues. If you put up your hands, the staff delivers the roving microphone to you. Anybody from the audience? Yeah, at the middle and in the. Would you, anybody to bring the microphone to her? Yes. Identify yourself,
Sure.
name
Hi.
and organization. Yes, please.
This is Eun Kyung-sung from Korea Aerospace University. So I have a question to Mr. Oplu. So can you tell us briefly what will be included in Annex 20?
Andrew, you wish to take? Okay, go ahead.
Thank you for your question. And the answer is I don't know. For the benefit of those who may not know, we currently have 19 annexes, and the last annex that was adopted was actually an addition to Annex 16. So our innovators, I'm sure, are working on various topics, and one of these days, one of those may evolve into an Annex 20, but I don't have a name or a scope for it.
So to follow up, do you have any plans to make an annex on cybersecurity or cyber attack?
Currently, a cyber attack is considered to be potentially an act of unlawful interference against civil aviation. And we already have Annex 17 that deals with acts of unlawful interference. And there is a standard 4.9, I believe, that covers measures that states should take to deal with those acts of unlawful interference which are committed by cyber means.
Thank you for your question. It's very important, the question regarding Annex system of ICAO. So the new technology will come to the existing manned systems, a new entrance, a new player by the new technology accommodation. So whether or not we need to do another type of annex or standard kind of, but the ICAO already take into consideration about it a long time ago. But with that, I'm looking for another questions. Yeah, I see in the rear on the right side. Please, yeah, bring the microphone to him.
Thank you. I'm Calvin Sotieno from Korea Aerospace University. My question is to the last speaker, Mr. Matthews. I'm just wondering, why does the ratification process takes too long by the member states as far as the protocols are concerned? Taking, for example, the Montreal Protocol of 2014, I'm seeing so far it's only 36 countries, and it's 9 years down the line. Given the importance of these protocols, what could be impeding the process of ratification by the member states? Thank you.
Okay, go ahead, Matthew.
Thank you for your question, and I believe it's a very good question. And sometimes we are also wondering why it takes so long for instruments to enter into force. But I just wish to point out that in the case of the Montreal Protocol of 2014, basically the protocol was adopted in April 2014. It entered into force almost 6 years later, which is considered to be relatively short compared to other recent instruments that have been adopted. And also on this specific protocol, now it has been ratified by 36 states. And what we have noticed is since the beginning of the pandemic, a number of states they have seen the need for the ratification of this particular protocol, and a number, I think we, over the past year and a half, there have been something like over 10 states or maybe 12 that have ratified. So it shows that presumably, with the current situation, with the increase in unruly passengers on board aircraft, presumably this has triggered some interest by states to ratify the protocol. So I don't know if this answers your questions. Yes.
Okay, I hope that answered your question. So next, I would like to pick up one of those questions from the online streaming. It's addressed to Michael Gill. What do you believe is the biggest achievement of ICAO legal committee, and what's your plan to further develop such achievement to keep sustainability? Mike.
Thank you for the question. If I had to sum up very quickly what I thought the legal committee's biggest achievement was, it goes back to the remarks I made, which is around just the number of international air law treaties which the legal committee has successfully negotiated and adopted. As I said, some 24 treaties over the 75 years. But it's not just about the volume of instruments adopted. I think you can measure their success by the high level of ratifications of some of those treaties and their day-to-day application. So just taking the Montreal Convention of 1999 as an example, around 140 contracting member states who've ratified, but MC 99 now covers the vast majority of international traffic. It's facilitated, for example, the use of electronic documentation for passengers and for cargo. It's governed the compensation for victims of a number of significant aircraft accidents. Take the Cape Town Convention. It now governs a significant number of aircraft transactions. You look at the Tokyo Convention of 1963, almost universal application. It is applied on a day-to-day basis to a number of incidents taking place on board aircraft. Of course, improvements have been brought around by the Montreal Protocol of 2014. So I think it's the treaty-making function of the legal committee. What are our plans going forward? Well, I think if you look at that success, it's been largely built on the fact that those treaties go through a fairly lengthy and painstaking process around building consensus amongst member states, getting input from a broad range of views, getting input from industry stakeholders where necessary. That's proved successful. And I think in the current context of trying to look at post-pandemic recovery, trying to look at ICAO's role in building a sustainable sector, I think that concept of building consensus amongst states, amongst a broad group of stakeholders is as important today as it's ever been.
Thank you, Mike. It'll be helpful to the question. So one more question from the audience, the gentleman in their left side. Please bring the microphone.
Thank you. Thank you very much. I have a question for Michael. During the making of a treaty, the first thing is to have the treaty, to finalize the wording, the negotiations, and then we take the next step. Then we have when the treaty gathers the minimum number of ratifications to come into force, and then we open the ratification for everyone else. But we see what has been mentioned before, how long it takes to get a universal or almost universal application of the treaty. And I know the efforts that ICAO has done through the years to try to promote that, but are we thinking of something else, Michael, that we could do in ICAO, you could do in ICAO to continuously promote the ratification of these many international law instruments that are there, that some of them have come into force already, but unfortunately, we still see like the Montreal Protocol of 2014, which is a much needed protocol worldwide. We see really still a small number of countries ratifying this instrument. Is there any structured effort to promote this from ICAO? Thank you.
Thanks. It's a very good question, because if you do look back over history, as I said, there are a number of treaties where there's a high level of ratifications, but it does take a significant period of time, both in the negotiation and adoption, but then the entry into force. I think it's a function of the way that many governments work, where you have different people responsible for those different stages of the process. It's a function of the fact that people change roles, priorities within administrations can shift. And that's not a criticism, that's just a fact of life, and many in this room would know that better than I. What we're trying to do within ICAO really is to take every opportunity possible to promote the ratification of those treaties. Events like this are absolutely fundamental, so I hope that everyone in the room who has responsibilities for these matters will take away the key message that it's not enough for us to have adopted these treaties. Member states have to then go the next step and formally ratify them. But we also continue to promote it through the Assembly resolutions. As Mathieu mentioned, at the Assembly this year, we again will have a ratification event where we hope it will facilitate the ratification process for member states, because they can come to a single event where they can deposit an instrument or instruments of ratification of a treaty. They'll gain the right level of profile and political buy-in through doing so at the Assembly. And we also rely on our leadership within ICAO, the President of the Council and the Secretary General, in their meetings with member states to continue to promote the ratification of the treaties. But it's a collective effort. I think it really does fall on everybody who's involved in these matters at any step of the process to do what they can to push through and to promote that whole process. Thank you.
Thank you, Mike. For the time constraint, I need to wrap up some of it. So my last quick question to Michael as well. Many of the legal experts and technical experts are interested in how ICAO and Chicago Convention accommodate new technology into existing mandate air navigation system. So I would like to emphasize the fact that, to me, the framework of the Chicago Convention is very flexible enough to accommodate the technological and socio-economic and geographical change over the last 75 years, but there's been no urgent amendments needed for the Chicago Convention. That's a fabulous one. However, now we are facing a lot of new technology changing, innovative aircrafts coming in 10 years, looking into 10 years, the autonomous ambulance or RPAS or air taxi, UAM, and the supersonic aircraft. So many different types of technology will come into the existing air navigation system formed by ICAO Annex and Chicago Convention. The 19 ICAO Annex, the operating like one organ of air navigation system, so it's not easy to disrupt existing the form or system of standard of ICAO. I understand. However, the technological innovation is so fast. It's coming into reality. So if you compare to audience as a director of a legal bureau of ICAO, how to say ICAO, how to respond to the new technology innovation in 10 years?
Yeah, it's a very good question. I think my simple answer would be that that's going to be the subject of a presentation tomorrow, how ICAO is responding to some of these new technology developments. So I think there'll be a lot to hear from that presentation. That was the easy answer. I think the slightly more complex response I'd give would be to say it's very tempting to look at a treaty that's 75 years old and say, well, it must be out of date. We must have to modernize it. There must be a better way to do things. I would challenge that premise and say that there is sufficient flexibility within the system, as you've said, both through the way we can amend the convention itself, but also through the adoption of technical annexes. And that's proved successful in a whole range of different areas, as we saw in the course of the presentations. It's proved successful that we're able to adapt to new and changing challenges. For example, the environmental challenge. When the Chicago Convention was adopted, it wasn't, I don't think, conceived by the states that the Civil Aviation, International Civil Aviation Organization would have to look at the environmental challenge. But we successfully pivoted and were able to respond to some of those challenges through the adoption of Annex 13. Well, I think we'll be able to do something similar in some of these new technology challenges that we're going to face in the coming 10 years. So I wouldn't start from the premise that we fundamentally need to amend the Chicago Convention or have a new international treaty. Thank you.
Thank you very much, Mike. So I would like to conclude our session by thanking all our great speakers for their excellent presentation, as well as all the audience who had the very good comments and questions and forward-looking statement, kind of. So thank you very much, everybody. So would you join me in thanking the panelists with a big round of applause? Thank you very much, all. It concludes our session 1. Thank you for your participation. Bon appétit.
Thank you very much. Please give an additional applause for the moderator, you, for smoothly leading this first session. Thank you very much. So we'd like to invite your seats back. Thank you very much. And it was time to think about ICAO's role regarding legal problems in the international aviation sector, and I hope you will join in legislating necessary areas and establishing order in the sky. We'll wrap up the first session, and we'll have the second session after your lunch. Your lunch will be served at Grand Volume 1, just next door, so please make your way to the next door. Thank you very much, and please enjoy your lunch. Thank you.